the docket. That is case number 117723 in the matter of the adoption of baby boy CL.
May it please the court, my name is Pantaleon Flores Jr. I represent LV, the appellant in this case. I would request up to 4 minutes for rebuttal.
4 minutes is granted.
Thank you. This case comes before the court following the birth of a child, which will be 2 years ago tomorrow, and the attempt at termination of parental rights that was filed in Wyandotte County District Court. By way of brief review of the facts, the child was born on September 13, 2016 to a mother who did not know that she was pregnant until the day she gave birth. There was no indication that she was pregnant. Upon giving birth, she signed a relinquishment to the Kansas Children's Service League of the child, and they contacted LV to advise him that a child had been born, and he immediately asked if he could see the child, meet the child. He asked who the mother was. They refused to tell him who the mother was. He found out through Facebook that the mother had been in the hospital. He contacted her to find out why she was in the hospital. She lied about why she was there. She said that she'd been cut open, but didn't know why. KCSL then contacted him a few days later to come in and sign a relinquishment. He said, "I'll think about it." The next day, they contacted him to come in, and he said, "No, I want to raise this child if it's mine. I'm going to be its father, and I'm going to do what I need to, and I'm going to hire a lawyer." On September 20th, LV filed a paternity action in Shawnee County District Court, where the child was born here in Shawnee County, seeking custody of the child so that he could raise the child, support the child, financially, emotionally, and in every other way. The agency, KCSL, hired an attorney to represent the mother in the paternity case and obtained a stay because, unbeknownst to the father, the day before his petition for paternity was filed, an adoption proceeding was filed in Wyandotte County District Court, where the child had been placed by the agency with the prospective adopted parents. The adoption proceeding did not proceed timely. There was a hearing scheduled for November 28th. LV was notified of the filing of the adoption and reserved with a notice to appear on November 25th, 3 days prior to the hearing.
When he received that notice, was that the first notice that you or he knew of the adoption proceeding in Wyandotte County?
No.
Okay. When did you have an understanding of that action taking place?
We had learned that there was an adoption proceeding in Wyandotte County at the time of the hearing on the petition for temporary orders in the paternity case in Shawnee County. Okay. But nothing had been done in that case. We later found out that there had been a motion filed by counsel for the adoptive parents to extend the 60-day period within which the adoption should be heard. And that was apparently granted, and then that's why the hearing was scheduled for November 28th.
Did you attempt to do anything to intervene or to do anything in the adoption case once you knew about it?
No. We weren't sure that they were going to proceed because of the paternity action. We did not do anything affirmative other than filing the paternity case and trying to obtain custody of the child.
Did the order in Shawnee County consolidate with the adoption case?
No, it stayed.
I was under the impression there was some language that the paternity issue and support, those types of things would be in visitation, would be considered within the umbrella of the adoption case? Do I have an incorrect understanding of the record?
Well, I don't believe that that's inaccurate. In part, the district court in Shawnee County deferred, believing that there had been an order for DNA testing already entered in the adoption case, which had not occurred until the November 28th hearing, at which time my client, by December 13, had his DNA testing completed. And so, until there was a determination of actual parentage, there were no orders entered.
Since we're talking about facts, let me ask a couple more because I wasn't able quite to track down this. As I've got it figured out, on Thursday, September 15th of 2016, the father was told that he was a father, or thought to be a father. So that's on Thursday. On the following Monday, the petition for adoption is filed. And then you come in the next day and file your paternity, and that's filed in Wyandotte County, the petition for adoption by the people that want to adopt the child. And then you file your paternity action the next day. Okay, that's, if I got that part right?
Yes.
Okay. Is there anything in the record that indicates that when the adoption agency learned, and I think it was on Friday the 16th, that your client was going to proceed to court to determine paternity, is there anything in the record that indicates the adoption agency investigator told the petitioners that your client was about to go to court?
I don't believe that issue was ferreted out in the testimony, except through the entry of the notes of the agency into the as an exhibit at trial, and there was testimony at trial that had occurred.
That they had that the investigator had notified the petitioners for adoption that you guys were about to go to court.
No, I don't believe that there's anything in the record to that effect. But
Is there anything that the investigator learned that the petitioners were going to go to court and told your client?
No.
And the reason I'm asking is there's a reference in Judge Malone's concurring opinion about a race to the courthouse. And usually a race involves two runners that both know they're headed to the same place and want to get there first. I'm wondering whether only the petitioners knew that there was a race to the courthouse and that's why you got beat. Because the timing is important, because then they come in to Shawnee County and say, we've got this Wyandotte County lawsuit, so Shawnee County can't go forward. And then a bunch of extra hurdles, in my view, got set up for the father because of the successful race to the courthouse by the petitioners.
I believe that the reason that Judge Malone indicated there was a race to the courthouse was that it was very obvious an inference from what had occurred when my client said, no, I'm not going to sign a relinquishment, and I'm going to hire a lawyer and seek custody of my child. Within a working day of that event, the adoption petition is filed. Knowing that there's no relinquishment on file by the agency, I cannot imagine that they could not or did not communicate that to the petitioners, because in the petition they indicate that there was no consent from the father. And so I believe that's how the Judge Malone came to the conclusion that there was a race to the courthouse.
Another factual clarification, I think you recited that your client father attempted, or when that initial phone call was made, he said, can I see the child? But I didn't catch what happened after that.
Well,
what was the answer to that question?
The record reflected that there was some confusion about what actually transpired, but in the end, the way it came out in the Court of Appeals opinion and the facts as they were from the notes of the agency were that he had asked and he was told, well, maybe, but come in and sign the relinquishment and we'll let you know. So it was in the context of signing a relinquishment that he might be able to meet the child, which he refused to sign.
It was conditioned on signing the relinquishment, is what you're saying.
Yes. Now, unless there's another question, I want to turn to what the Court of Appeals correctly held, that the district court's finding under 592136H1A was incorrect and reversed that finding. That it stated that the father had not abandoned or neglected the child after having knowledge of the child's birth, in large part because there was no opportunity, an insufficient opportunity existed within which to engage as a parent or willfully abandon the child with no intent to return. And that's on page 11 of the Court of Appeals opinion. And I think that's very instructive of what the facts in this case really were. There was no opportunity other than what my client did in those 5 days. And really what we're asking you to do is just to look at this case in light of the opinion that was rendered in Baby Girl P, which basically says that the effort to be a father, the support and communication attempt, is the starting point. It's not the ending point. And did my client do enough? I believe he did more than enough. When you look at this case and you compare it to Devon in the Baby Girl P case at page 434, what did he do? Well, he immediately sought visitation. What did my client do? He asked to meet the child. Same thing. Devon offered to the custodians anything they might need. Even though he didn't provide anything, he offered. My client filed a paternity action seeking to be able to provide for the child. And in Baby Girl P, there was an expression of a desire to assume the duties and responsibilities for the child, which is exactly what my client did in those 5 days. And in that case, this court determined that it was enough to preserve the parental relationship of the father. That was enough. A Herculean effort is not required. What is required is that the father abandon that effort, and it never happened in this case. And so the Court of Appeals framed the issue as whether or not the acts were sufficient to avoid termination of parental rights, which I believe was the incorrect issue for them to try and look at. They needed to look at what he had done in order to assert his right. And what he had done was equal to or exceeded what Devon did in Baby Girl P. Devon in Baby Girl P did not file a paternity action. My client probably knew that there was an adoption coming. And I will not stand here and say that we didn't act as quickly as we could to get a paternity case on file, because a relinquishment signals adoption. And he wanted to raise his child, and he wanted to assert that right immediately, which is what he did. And we ask that you reverse the Court of Appeals decision, which placed a much higher burden on him than was required by law. And
what was his understanding of the parameters of the restrictions put on by both courts as to his contact while the case was pending? It seemed to me he had an understanding that he wasn't allowed any kind of contact or any kind of interaction with either the adoptive parents or his child. Is that accurate?
yes, that is what the record reflects.
And where does that emanate from? From the paternity case, the adoption case? Was there a court order in place? Where did that understanding come from?
Well, it came, I believe, from two sources. One, from how he interpreted the stay in the paternity case, and the request in the adoption case by the parents to have the information in the petition confidential, not be disclosed to him, so that he wouldn't be able to know where they were and directly contact them.
What are we to make of, or what can we make of the actions of the child placement agency? Do those actions have any relevancy to our analysis?
Well, the adoption statutes don't appear to directly govern what the agency can or cannot do. Once the relinquishment was signed by the mother, then they assume the status in loco parentis, if you will, for the mother of the child. And so
Part of the tenor of your argument, and correct me if I'm wrong, but as I read it, is that the agency sort of threw up roadblocks. They actively worked to inhibit your client's ability to see the child, to make contact, to provide support, to do all the things that the statute says that the father should do.
that's absolutely correct. That's our belief.
And if let's just assume for purposes of the question that you're right, that those facts exist. I'm just trying to understand how we fit that into the calculus, since the statutes are silent about that.
Well, I don't know that that's necessary, except to examine it in the context of, well, did the father then just give up and walk away? He did not. He continued to pursue his parentage of this child, his right to raise the child and be the child's father. I believe those impediments were put up there to see if we could maybe discourage him from going forward, and which is in line with serving him 3 days
So you're
before
just
the
saying,
hearing.
given the unique facts of this case, he did everything he believed he reasonably could do.
Yes,
And reasonableness is the touchstone.
yes.
And if they put the impediments or the obstacles, then we have to judge the reasonableness of his actions against the circumstances he was facing.
Absolutely.
Who signed the petition for adoption?
I believe it was both of the natural parents, or excuse me, the proposed adoptive parents who signed the petition. The redacted petition that was provided to us indicates that the petitioners and the proposed adoptive parents were the petitioners, and they signed a verified petition.
Well, my recollection is that the counsel for the petitioners signed the petition, that the prospective adoptive parents verified the allegations in the petition, and that counsel for the petitioners also notarized their signatures where they swore that what was in the petition was factually true.
That is correct.
Is that right?
Yes.
Okay.
Do we have any further questions? Thank you, counsel.
Thank you.
Good morning. Let me start.
Before you get started, could you verify about the petition? Who all signed it, and was it verified?
Excuse me, before you even do that, since this is your first time on camera, could you identify yourself and who you represent, and then answer Justice Johnson's question? Thank you.
Yes. I am, may it please the court, I'm Kevin Kenny, and I represent the adopting parents at Belize. To answer your question, Your Honor, it was I who signed the petition, and as the probate code requires, my clients verified its allegations.
And let's look at that. The petition alleged grounds for termination that the identified biological father, after having knowledge of the pregnancy, failed without reasonable cause to provide support for the biological mother during the 6 months prior to the child's birth. Is that true?
That was alleged, yes.
How could that be when he didn't find out until after the child was born?
Your Honor, it's a reasonable question. I was informed by the birth mother that she didn't know that she was pregnant until she had arrived at the hospital.
She didn't know she was pregnant until she went to the hospital and had the baby.
Correct.
And you're alleging that the putative father had knowledge for 6 months before the mother knew?
Let me explain. Your Honor, I've been doing adoptions for a long time, and birth mothers have been untruthful to me in the past. And I don't know why she would have said she didn't know she was pregnant until she showed up at the hospital, but out of an abundance of caution, we alleged that specific statutory ground just in case.
And what are your facts for the second allegation, that the biological father abandoned the biological mother, after having knowledge of the pregnancy? What's your facts that would support that allegation?
Again, Your Honor, birth mothers have lied to me in the past. We alleged all pre-birth grounds, as it were, out of an abundance of caution.
I guess I don't understand the abundance of caution, particularly since this is a verified petition. You have to have a factual basis to make a claim in a petition, regardless of whether it's an adoption case or any case, right?
Yes, Your Honor.
And so you're saying that your factual basis for making this allegation was that you thought it was possible that the birth mother was lying to you, and so you claimed facts that you didn't know whether they were true or not.
That's essentially correct, Your Honor, but...
And then let me go one step further. The adoptive parents, these people that want to have this child, are verifying under oath that there are facts to support something that nobody knows is true. How does that happen?
Your Honor, as I explained, we alleged this.
I know what you did. I'm trying to figure out how it happens. It's not enough to just say this is a statutory allegation and I'm going to throw it into a petition and put my name on it as a licensed lawyer, or to have my clients verify that that is true without a factual basis, is it?
That's correct, Your Honor.
And is that something that the district court should have taken into consideration in weighing all these different facts that had occurred up to the time of the adoption?
I don't think so, because the district court, nor did the Court of Appeals, rely on those specific allegations of the petition.
I know they didn't rely on it. My question is, should they have taken that into consideration? I mean, you guys are making claims that aren't true or aren't supported, for sure. And I think you've even agreed they're not true. So doesn't that weigh into the analysis of what's going on here, particularly in relation to the race to the courthouse aspect of this, and the fact that you used this petition, for which you did not have a factual basis, as a hurdle, to use the language of Baby P, as a hurdle to keep this father from having his parental rights recognized?
Judge, the petition and the adoption case in and of themselves were not hurdles to the father.
How could it not be a hurdle? And the reason I say that is because you used the existence of the petition, which you got to court before they did,
Sure.
to keep them from proceeding with the paternity case in Shawnee County.
Your Honor, when I filed my adoption petition, I had no idea that a paternity action was forthcoming.
Okay.
But wasn't the defense or the answer in Shawnee County that there is this adoption and you need to stay the paternity?
Yes, we learned of the paternity action after we had filed the adoption action. I didn't know about it when I filed my adoption petition.
And did the petition serve as part of the basis for the 60-day continuance or extension?
The petition in and of itself did not request the extension, but we set the initial hearing toward the end of the 60-day statutory period.
So it eventually became a hurdle then.
The petition?
Yes.
Not in and of itself, Your Honor.
You used it to your advantage to keep the essential proceedings in Wyandotte County, correct?
Your Honor, we filed in Wyandotte because that was where we had venue. I always file my adoption petition as soon as I can after the child is born.
Why wasn't paternity front and center in this adoption? I mean, almost immediately determined, especially where a father had filed a paternity action and asked for the right to support and raise his child.
I'm not sure I understand the question, I'm sorry.
Well, rather than delay the adoption proceeding, why didn't the question of paternity get addressed very quickly?
Under the adoption code, Your Honor, a birth father is entitled to notice of the initial hearing. He can elect to appear or not appear. If he appears, it's his burden under the Kansas Adoption and Relinquishment Act to assert custodial rights. At that point, the district court is to determine paternity, and customarily that's done by DNA testing. So I hope that answers your question.
It seems though that this was delayed, and I don't understand why there wasn't quicker action taken.
In what regard?
In the hearing on the paternity. And once, as I understand it, the DNA testing occurred fairly quickly?
It occurred in, I believe it was January. The father appeared and was ordered to arrange and pay for DNA testing. He scheduled his own appointment, scheduled an appointment for my clients, but hadn't cleared it with their schedules, so they were delayed in having the baby tested. But paternity was ultimately determined in January.
And I guess part of the reason why I'm focused on the lawsuits and whether they were hurdles is because of what the Court of Appeals said.
Yes, sir.
And there they talk about, the father argues that the acquisition of counsel and his involvement in both Wyandotte and Shawnee County proceedings, the court proceedings, should be considered as efforts on his part to support the child. Then the court says, the outcome of this appeal hinges on whether these acts are sufficient to avoid the termination of the father's parental rights. And so when I'm looking at how you got to court and what happened once you got to court, those hurdles, again using the language of Baby P, seems to me to be pretty important to the Court of Appeals, forms the basis of why they did what they did, and that's what we've got to look at. Would you disagree with that?
Good. Can you restate the question, or I'm
Yeah,
not sure I'm following you.
It looks to me like the Court of Appeals is saying, well, I mean, they do say the outcome of this appeal hinges on whether these acts, hiring Mr. Flores and playing in both of these two courthouses, is sufficient. It should be considered on his part to support the claim. Then they say the outcome of this appeal hinges on whether these acts are sufficient to avoid the termination of parental rights.
Sure.
And so what's that's telling me is that we've got to look at how all that happened, because that would be the hurdles. And I'm also reading this as saying to avoid the termination of parental rights, which tells me they just shifted the burden of proof over to the father.
May I address your question?
So that's what I'm
Sure.
I'm just saying that's what I'm looking at. Tell me if I'm right or wrong.
Your Honor, I think what the Court of Appeals said was, yes, father did file the paternity case in Shawnee County. And ultimately, it may have satisfied his obligations under 592136 H1C to provide reasonable efforts to support and make reasonable efforts to communicate with the child. The father made the strategic mistake of relying solely upon his paternity action as a demonstration of his commitment to the child. And the Court of Appeals was very blunt in saying this standing alone is not enough. Something more from father is required, actual support and actual communication with the child.
What did he ask for in that petition for paternity? Didn't he ask for establishing his parenthood, that they establish child support, that he have custody of the child? All of those things were part of the petition for paternity, were they not?
Yes, Your Honor.
And
they were.
you or your clients stopped that. But for you're going into court and staying that proceeding, he would have affected what you're saying he didn't do. He was legally stopped from doing what you're saying he should have done.
Your Honor, the paternity case was stayed. You are correct. However, the stay order, and father claims that the stay order from the Shawnee County paternity case prohibited him from supporting and communicating with the child, but on the record, in the district court, he admitted that that was not true. The salient point to address your question, Your Honor, is that even though father could not have done what he said he wanted to do in the paternity case, there was nothing that prevented him from supporting and communicating with the child through the adoption
on that point,
case.
though,
Yes,
he's not given the names of the adoptive parents,
that's correct.
so he has no way of contacting them.
He could have contacted them through me.
I understand that, but he has no way of contacting them directly.
That's correct.
So the only points of contact between the father and the child, either for purposes of communication or support, would be either through you or through the adoptive agency.
That's correct.
Was
Yes.
he ever given any instruction or information that this is how you go about supporting this child, either contacting counsel for the adoptive parents or contacting the adoptive agency?
I did not, Your Honor. I don't know if the agency did.
Well, isn't it reasonable to assume that the father would think that these things are going to get resolved by the court? Is it reasonable to assume that the father would know that in order to do the things that he's being criticized for not doing, that he should have contacted you or the adoptive agency?
I think, to answer your question, Your Honor, Kansas law is clear that the burden is upon the father to take immediate efforts, because his opportunity to save his constitutional right to parent his child is very short-lived.
Which is true, but it's also judged by what's reasonable.
That's true.
And I guess my question to you is, how does the father know that these are the only 2 points of contact for either providing support or having communication?
How does he know?
Yeah.
How does he know that these are the only ways he can provide support and communicate, or how does
Well,
he
he
know?
can't give support directly to the adoptive parents, and he can't communicate with the child except by arranging that either through you or the adoptive agency.
True.
So the points of contact that the father has, or the ability for him to do what he's being criticized for not doing, is only through 2 points, either through you or the adoptive agency.
That's correct. Yeah.
And we're assuming that he knew that this is how he was supposed to do that.
Your Honor, I don't know what the man was thinking. He had an attorney almost immediately after the birth of the child.
Well, the one fact we know is that when he in fact did try to avail himself of one of those contact points, he was told, you got to come in and sign a relinquishment.
That is not factually accurate, Your Honor. There were some discussions about him signing a relinquishment, and as part of that discussion was what we refer to as open adoption. And he had asked, could I see the child? And I believe that the representative from KCSL said, yes, we can talk about that. There was no quid pro quo, and she was not trying to throw up an obstacle to father.
Well, why wouldn't the correct response be just yes, you can see the child? I mean, and Judge Malone pointed this out in his concurrences. It's very concerning that it seems the agency itself, even before the adoption petition and the stay was filed, just within hours or days of the child's birth, was putting up hurdles. That's
Sure.
what they were doing.
Your Honor, the adoption agency has a job to do. And the natural mother has a constitutional right to place her child for adoption. When she relinquishes to an agency, it's the adoption agency's job to carry out her wishes, not to prevent termination of his parental rights. Birth father has his own work to do, to show that he has demonstrated that he is committed to his child by taking immediate action. And if he does not do so, he forfeits
You're saying that
his rights.
the agency stands in an adversarial posture towards the birth father because the adoption agency has a duty to see that the child is adopted?
No, I don't think
It sounds
there
like
is-
what you just
Yeah,
said.
let me explain. I didn't mean for that to come off that way if it did. My point was that the biological mother decided to place her child for adoption, which is her right. She sought out an adoption agency, KCSL, and KCSL took custody of the child. Its role in an adoption is to place the child with the adopting family. Its role is not to provide assistance to the birth father. That's incumbent upon him to seek out counsel and figure out what he needs to do.
But don't we have, our case law says that both parents have an equal right to custody of the child. And if he is the father, he has a right to have custody of the child until he's deemed unfit, right?
No, sir. The Kansas Adoption and Relinquishment Act says that a birth mother can place the child for adoption, that a birth father's rights may be terminated for any of the statutory grounds
I
listed in
understand that. Let me ask you
592136.
something. Let me ask you something else. Which is more reasonable? Sending some money to you and hoping it's enough to avoid abandoning parental rights, or asking the court to set an amount of child support that will be legally sufficient? Which is more reasonable?
If we think about it, Your Honor, in the paternity case, that action was stayed, and I guess, father did acknowledge that he had some duties to the child. I think in the context of this adoption,
You're not answering my question. When we talk about reasonable efforts,
Mhm.
if he sent you money, he still would have to fight about whether that was enough money to fulfill his obligation.
Sure.
If he gets a court order that child support is this amount of money, then he knows that he's not abandoning his parental duties because the court has set that amount. And so I'm asking you, from his standpoint, which is more reasonable course of action? Just to send money to you or to ask the court to set the amount that he owes?
I think in the context of an adoption, the Adoption and Relinquishment Act says he has to provide reasonable support, and it has to be more than incidental. It does not have to be total support. I mean, the case law is pretty clear on what a father needs to do. I think to protect his rights in the adoption case, the latter, providing money to me in an amount that he and counsel had decided was more than incidental, would be the more reasonable course of action.
Counsel, you had mentioned in response to Justice Stiegel's questions about the role of the adoption agency. You've done a lot of these things, and I've done related stuff, but never in the area of adoption. Are there contractual relationships with these adoption agencies with the state? Are there regulations or are there statutes that we can look to define what the role of the agency was in this process?
There may be statutes, I'm unaware of them. I know there are regulations. I cannot cite you to them. I know that they're required to perform certain acts to renew their license and provide
So
certain.
they're
activities.
licensed entities.
They are licensed by the state, yes, Your Honor.
So there would be regulations. Any
Yeah.
contracts
With,
with between the state and the agency?
I don't know. in
Well,
this
there
particular case.
wouldn't there be? I mean, doesn't the state pay the agency? Isn't that how the agency is paid? That's
No,
am I wrong about that presumption?
The adopting family pays the agency.
So, okay.
My clients do.
So to your knowledge, they're not receiving payment from us, from the state?
Not in an adoption where the child was not in state custody.
Okay.
This child was not.
So
With
excuse me, go ahead.
I was going to say, with respect to the adoptive agency, it's my understanding of the facts that mom gives birth on September 13th.
Yes.
Within a couple of days, the child is given to the custody of the adoptive parents, and this was arranged by the agency.
Yes.
Was the child in the custody of the adoptive parents before the father was notified that he was the father?
I don't know, Your Honor. I don't think so. Mother delivered on the 13th. I don't have the exact date that she signed her relinquishment. I know the assumption of custody by my clients and the notification of father was pretty close in time. I can't say that one occurred before the other.
Well, he was contacted on Thursday, September 15th.
That's
Another
correct.
signed relinquishment on September 15th.
So then the answer would be yes. It sounds like it all happened the same day.
This, I'm going to ask, this is going to be conclusory, but I'm asking you to disabuse me of the notion. It almost seems to me like we dropped this father in the middle of the Hunger Games. And we've said if you can be strategic enough and clever enough to deal with the obstacles, you can avoid having, according to the Court of Appeals, you can avoid having your parental rights terminated. How am I wrong in viewing what happened here in this way?
Well, Your Honor, nobody tricked this young man. He was represented by counsel almost from the start. He has a common law duty, as the court knows, to support his child. The Kansas Adoption and Relinquishment Act is also very clear about what he needs to do after the child is born. That's make reasonable efforts to support and communicate with his child. Counsel had referenced baby girl P as supportive to their position, but the Court of Appeals specifically found that baby girl P, which requires a reasonable but not extraordinary efforts, didn't help the father in this case. The father in that case did provide some support, visited with the child, provided some Christmas cards, and that was sufficient in the eyes of the baby girl P court.
But the baby girl P court specifically noted that the father had not initiated a paternity action. So you add that into the mix. I mean, that was kind of what I noted when I reread baby girl P, right?
And
You were in
baby-
that. I mean, you were counsel in that case.
Yeah. Father had not initiated a paternity case, although I don't know that it factored into the ultimate decision of the court. The court did note that the father had requested and received some visits with the child. I think that was the distinction.
We have time for one more question.
I've got one if no one else does.
All right.
The adoption agency, you said, gets paid by the adoptive parents.
Correct.
Is that payment conditioned upon the adoption going through? What I'm trying to determine here, it almost seems like we have an adversarial circumstance, as my colleague suggested, between the agency and the father when it comes to terminating his rights. And if they have a dog in the fight, then I think that changes at least my view of what happened and what the hurdles mean.
Sure, that's a fair question, Your Honor. Customarily, the adoption agency is paid no matter what. If the birth mother does not decide to proceed, then that money will carry over for a future adoption. So their remuneration is not contingent upon termination of the biological father's rights, and thus they would not be against him.
But just to put it in raw economic terms, the agency does lose one adoption. And if their income stream is essentially contingent upon the number of adoptions that they complete, how is it not the case that they have a financial interest in seeing the adoption completed?
I see your question, Your Honor. I think the answer to your question is it's a matter of ethics. Agencies are ethical. At least this one was.
Counsel, we've used all of your time for our questions. Would you like to wrap up your position in about 30 seconds, or do you believe you've made your points?
I think I've made all the points I wanted to, Your Honor. Thank you.
Very well. Thank you.
Okay, thank you.
I'm not sure how much time I may have left. I will keep this brief unless there are a lot more questions. But I did want to point out an additional fact as it relates to the period of delay that took place between the filing of the petition for the adoption, the service of the notice on my client, and the hearing that was held on November 29, 2016 at 9:30 in the morning in Wyandotte County. That hearing had actually been scheduled on October 25th, 2016, and that's in the Record on Appeal Volume 2 at page 100, where the order for the hearing establishing that November 29th date was scheduled. I think it's significant that my client wasn't served the notice of the hearing until November 26th, a Saturday at 5:07 p.m., because had he, on the way to the hearing, had a flat tire and not been there at 9:30, then a different set of law would have applied to this adoption case.
Do you know how that delay happened or how that occurred?
It
Who controls the notice?
It was incumbent upon the petitioner's counsel to get that notice served.
So it's the petitioner's counsel didn't notify your client and you until 2 days before the hearing on a Saturday.
Yes.
One more question, just a fact question. Didn't your client add the child to his work insurance as soon as he could after the birth? It was within 30 days as I looked at the record. Do you recall that?
That is what,
The work health insurance.
yes, that is what the record establishes. But there's a little distinction that I have to make, because although the record at the district court level and at the Court of Appeals level says that he placed the child on his insurance, he could not actually do that. He contacted them, made arrangements for the child to be insured, but he couldn't put the child on his insurance until paternity was established and there was an order for him to do so. So in actuality, the child was never actually insured, but he was set up to get that done as soon as he was legally able to. And so I've tried to make that clarification, but it just hadn't come across yet until today. And so I believe what was really hoped for by the prospective adoptive parents was that the adoption of AAT would have applied here. That is, that my client didn't show up at the hearing, and then we have a whole different set of rationale for terminating his parental rights. He doesn't show up, he doesn't assert his rights. He can be terminated whether he supported the child or not, because he doesn't argue on his own behalf for the child. And
Well,
so,
Counselor, the heartbreaking thing about these cases is that we have a 2-year-old now
that
that's
is,
been with the adoptive parents, that's formed a bond, And what you're asking us to do is sever that bond. How does that fit into our calculus?
Yes, that is exactly what I'm asking you to do. And it fits along in the same line as the rationale in Baby Girl P, and is what the Court of Appeals stated, that it's a heartbreaking thing that has to occur. But the father's constitutional right to parent his child is paramount here. We have a parental preference doctrine in Kansas, and we cannot reward those who obtain custody, whether lawfully or otherwise, and maintain it during an ensuing bit of litigation. That's what this court citing in the matter of Holloway adoption out of Utah stated in Baby Girl P at page 436. It went on to cite a U.S. Supreme Court opinion, Mississippi Choctaw Indian Band, for further support that the trauma that might result from removing these children from their adoptive families should outweigh the interest of the father and perhaps the child herself, having to be raised by the father. Neither of those were sufficient. It is not for the court to say what trauma would result in determining whether or not there should have been a termination. There no doubt will be some, but that is the unfortunate fallout of a case like this where, as Judge Malone noted, everyone should have taken a step back in the adoption proceeding, allow my client to pursue his paternity of the child, establish his fitness, and raise his child as he had a constitutional right to do so. Thank you.
Do we have any more questions? Thank you, counsel. I thank you both for your arguments this morning. Clerk will take this matter under advisement.